Visit Superior.
Hi, is the interpreter on the line?
Hey, good morning. Yes.
Hi, good morning. I'll be speaking to the defendant now. Sir, could I please have your full name and date of birth?
Le ayudo con el lenguaje. Díganos su primer nombre y apellido.
René Reyes.
Fecha de nacimiento.
18 de julio del 79.
July 18, 1979.
Thank you. You are here on a new case in the Superior Court and you are here on a failure to appear warrant.
Gracias. Usted está acá en un nuevo caso en la Corte Superior y por una orden de comparencia.
Sí.
On your failure to appear warrant, I'm not assigning you new counsel. You're going to go back to your original attorney.
Muy bien. En caso de no presentarse, no le asignaré una nueva consejera. Regresará usted con su abogado original.
Your next court dates will be June 11th and June 13th in the Downtown Superior Court.
Su corte próxima será el 11 de junio y 13 de junio en Downtown Superior Court.
Okay.
Your original judge has set a $500 bond.
Su juez original ha dicho que tiene una fianza de $500.
Please do not try to pay that bond.
Por favor, no trate de pagar esa fianza.
Because you have been arrested for aggravated assault, a Class 6 felony.
Porque ha sido arrestado por agresión agravada, delito grave, clase 6.
I am assigning you an attorney, and your next court dates are June 11th, 12th, and 13th.
Le estoy asignando un abogado para su próxima fecha de corte el 11 de junio, el 12 y el 13.
Okay.
Because you committed this offense while on release for your other offense, you are going to be held non-bondable.
Debido a que cometiste este delito mientras estabas en libertad por tu otro delito, no podrás salir en libertad bajo fianza.
Please step to your left for your paperwork.
Por favor, siéntase libre en revisar sus documentos a la izquierda.
Okay. Gracias. Thank you.
Angelis Reyes to the podium, please. Could I please get your full name and date of birth?
Angelis Medina Reyes,
¿Le ayudo con el lenguaje? Sí, díganos sus
Sí.
nombres y fechas de nacimiento, por favor.
Angelis Medina Reyes, octubre 15 del 97.
October 15, 1997.
Thank you. You are here on a Superior Court arrest warrant.
Gracias. Usted está acá en la Corte Superior por una orden de arresto.
Probable cause was previously found for 4 counts of organized retail theft, Class 4 felonies.
Y se encontró una causa probable para robo organizado en comercio minorista, delito grave, clase 4.
These events occurred between August of 2024 and May of 2025.
Este evento ha ocurrido entre agosto del 2024 y mayo del 2026.
I'm assigning you an attorney, and your next court dates are June 11th and June 13th in the Downtown Superior Court.
Le estaré asignando un abogado para su próxima fecha de corte, el 11 de junio y el 13 de junio en la Corte Superior, Downtown.
Your judge has set a cash bond of $2,500.
Su juez ha enviado una fianza en efectivo de $2,500.
If you are able to pay that bond and are released, you will be placed on supervised release.
Si usted es capaz de pagar esa fianza y es liberada, se le colocará en libertad supervisada.
You are also not to return to the scene of the crime, and you are to have no contact with any victim or witness.
No puede regresar a la escena del crimen, no tener contacto con ninguna víctima o testigo.
You're also not to possess any weapons, drugs, or alcohol.
Tampoco puedes poseer armas, drogas o alcohol.
Please go to your left for your paperwork.
A su derecha están sus documentos.
Okay, thank you for your help, Mr. Interpreter.
You're welcome. Thank you for calling Rich. You have a great day.
Thank you. For the last three individuals, I'll be visiting the back of their cell. They pose a risk of harm to themselves or to others. Sonia Overly, date of birth 12/28/91, is here on a grand jury warrant. Grand jury has found probable cause for possession of dangerous drugs, class 4 felony, possession of drug paraphernalia, class 6 felony, criminal trespass, class 3 felony. Offenses occurred back in March of 2025. I am assigning counsel. Next court date is June 12th in the Downtown Superior Court. Affirming the bond set by the grand jury, $2,500 secured. If she's able to post that bond, pretrial services supervision, not to return to the scene of the crime, no contact with any victim or witness, not to possess any weapons, drugs, or alcohol. Lori Watkins, date of birth 6/1/64, municipal court new case, arrested for criminal damage, class 1 misdemeanor. I have found probable cause. I'm assigning counsel. Next court date 6/25, June 25th at the Goodyear City Court. Upon a promise to appear, she'll be released on her own recognizance, not to return to the scene of the crime, no contact with any victim or witness, not to possess any weapons, drugs, or alcohol, must obey any orders of protection, may not reside with the alleged victim. Daniel Moraz, date of birth 11/20/1999, is here on 2 probation violation warrants. I'm assigning counsel. Next court date is June 11th in the Downtown Superior Court. Cash bond of $250 on the first one, cash on each, so total $500 cash bond. If he's able to post bond, not to return to the scene of the crime, no contact with any victim or witness, not to possess any weapons, drugs, or alcohol, must contact his probation officer within 24 hours. After visiting these individuals back at their cell, if I'm to change any of these release conditions, I will come back on the record to make those changes. This concludes the 5 a.m. calendar.
All right, thank you. Please be seated. All right, this is the 11 a.m. initial appearance calendar for June 5th, 2025. This court's orders for the taking of fingerprints and DNA from the court made on the 2 a.m. calendar on the 1st of the month will also apply to these hearings. And we're going to begin with Mr. Olvera, Pablo Olvera. After that, Brian Bates, will you go to the chair? Where's Pablo Olvera? He's dressed out. There he is. After that, Brian Bates, will you please go to the chair? The officer will show you where to wait. Right here, sir. Podium. Good morning, sir. May I have your full name and date of birth, please?
August 10, 1982.
Are you Pablo Antonio Olvera?
Pablo Antonio Olvera.
Okay, thanks. You're here on a new case. You were arrested for criminal trespass in the first degree. It's a class 6 felony. Oh, I think we had you listed, the police said that you...
I'm working.
That you needed a Spanish speaker? Oh, sorry,
No.
that you needed a Spanish interpreter.
No.
It appears you do not, right?
No.
Okay, I don't know why they listed that. Okay. So you got arrested for criminal trespass in the first degree. It's a class 6 felony. There is probable cause for it. I am appointing a lawyer to represent you. Your next court date is going to be a status conference June 19th, which is 2 weeks from today, June 19th, 8:30 in the morning. Preliminary hearing June 23rd at 8:30. I'm going to release you, okay? So you don't need to tell me anything at all. I'm already going to release you. You don't have any felony priors. And the allegations in this case, even if you are convicted, are probation eligible. So right now, I'm willing to let you prove whether you will or won't come to court. Do not go back to this location. No contact with anybody who owns it or any co-defendants you may have. Everything is on your paperwork. You just need to come to court in 2 weeks. Will you do that?
It's my job.
You're working
Can I tell you
there?
something? Yeah, I was working. I was working and somebody called the
They say
police.
the owner says nobody was supposed to be inside. So
because-
all I can tell you is,
Yes.
I don't know how, I don't know on what circumstances you ended up there. But I'm ordering right now, do not go back there. Do you
Yeah,
have
it's
tools
okay.
there or something? Do you have
No.
tools?
No, I have my tools and my
Okay.
wallet, my two phones.
I'm gonna give you permission to go one time with a law enforcement
Yes.
officer to get that stuff.
Yes.
But otherwise, I don't know what's going on in
Because
this case, but the police allege the owner said no one was supposed to be there. So,
Yeah, sorry, I never get contact with the owner because I work for somebody else.
okay.
So I never see the owner, but
Yeah.
yesterday somebody called the police and said somebody in the house, so I was working, I'm painting, I had the road and everything,
Okay.
and the police come and arrest me.
And if you're able to establish that will absolutely help your case. But here's what you need to know. This is just the start of your case. This is not the end. This is not your trial. So just listen, okay?
I just need to pick
I'm
my
gonna
wallet.
release you. The only way you can go back there to pick up your tools and your materials is if you bring a Phoenix police officer with
Okay,
you.
good.
You have to call the non-emergency number, request the civil standby. It's on your paperwork. They'll want
Okay.
to see that I gave you permission. They'll send an officer to go with you and keep the peace while you collect your stuff. And then
Thank
you'll
you.
have to work out the situation with whoever hired you separately, because right now, right now, you don't want to violate release conditions because you're being accused of a crime. It doesn't mean you're going to be convicted, but you are accused. You have
Yeah.
to take this very seriously, okay?
I understand.
All right, everything's going to be on your paperwork. Good luck, sir.
Thank you.
Oh, yeah, did you get the new one? Right, it needs to say the civil standby, because the police won't do it unless they can see it's on your orders. I've heard they won't do it, so,
Thank you.
okay. All right, good luck, sir. All right, where's Mr. Bates? And then it looks like that defense attorney is still talking to her client. I don't like to cut that off if I don't have to, so. All right, Mr. Bates, you're right here. After that, I'm going to do Brian Goodman then. Brian Goodman to the chair, please. Hi, sir. Can I have your full name and your date of birth, please?
Brian Anthony Mata Bates, 8481.
Okay, thanks. You're here on a new case, on a warrant in a pending case. I'm going to start with your new case. You're booked in on one allegation of possession of dangerous drugs. It's a Class 4 felony, and there is probable cause for it. I am appointing a lawyer for you. Your next court date is going to be June 11th, which is 6 days from now. That is a status conference in the Downtown Superior Court at 8:30 in the morning, with a preliminary hearing June 13th at 8:30 in the morning. You're also here on a warrant in a pending case. You've been charged with 2 counts of possession of a weapon by a prohibited person. Those are Class 4 felonies. You already have a lawyer in that case. Your last court date was May 22nd of 2025. It was a comprehensive pretrial conference. You were not there, and there was a warrant issued for your arrest. So we're going to set a status conference in front of the trial judge in that case. It's going to be June 12th at 8:30 in the morning. Eventually the cases should come together in the system, but right now, procedurally, they're at very different stages. So you do have to go to the trial judge for that status conference. Now, going back to the new case, I'm setting yet another hearing for you. It's called a bail eligibility hearing in the new case only. And the reason you need one of those is that there is probable cause for a new felony while you have any pending felony case. So that means I cannot give you bail today. What I must do is hold you for a bail hearing. The bail hearing will be in 1 week, June 12th, but at 1:30 in the afternoon. You'll see your lawyer the day before for a status conference. They can tell you what's going to happen at the bail hearing the next day. You may or may not be found eligible for bail in the drug case on the 12th, but you're not at all eligible today. You must be held. In the older case, I'm just going to affirm the trial judge's bond. It was $5,000 secured with release conditions, but you shouldn't try to post that until you know what's going to happen in the new case. Everything is on your paperwork. You should end up with the same lawyer for both cases. This gentleman has that paperwork for you. Thank you.
Thank you.
Mr. Goodman? And then Clinton Tabron, will you please go to the chair? Hello, sir. Can I have your full name and your date of birth, please?
My name is Brian James Goodman, Jr., and date of birth, June 30th, 1998.
Okay, I'm just going to add the junior. All right, Mr. Goodman, you are here on a new case. You were arrested on 9 allegations of organized retail theft of merchandise. Those are Class 4 felonies. 9 allegations of removal of a theft detection device. Those are Class 6 felonies. The offense dates in your case range from, April 18th to June 2nd of this year. There is probable cause for all of those, and I am appointing a lawyer to represent you. Your next court date will be a status conference June 11th at 8:30 in the morning in the Downtown Superior Court. Preliminary hearing June 13th at 8:30 in the same court, and everything is on your paperwork. Based on what's been alleged against you and your criminal history, the court believes you are a very substantial flight risk in this case, and you pose a high risk of not appearing for trial. You do face, you may be surprised to know, you face a considerable amount of prison time in this case, and the court believes that increases the possibility that you'll flee to avoid prosecution. It also appears you have access to illegitimate funds with which to post bail and flee. So all of that adds up to a large bond, Mr. Goodman. It is $100,000, and it is cash only, dollar for dollar. If you post it, you may not leave the state of Arizona without the advance written permission of the court. You may not go to the scenes of any of these alleged crimes. You may not possess any weapons. You are very much a prohibited possessor based on your extensive felony history. What's your question?
I just wanted to know, so basically, I had came out here to try to change my life. I was applying for jobs back to back to back. I was doing my best I can. I ended up getting a job interview with Walmart. They told me that they gave me the job. They gave me the job for seasonal. So I kept trying to get in contact with them because they wasn't hitting me back up as far as me letting me know in my background search. So I'm not going to lie to you. I started using drugs again. I started going back to fentanyl, alcohol, and stuff like that.
Be careful not to accidentally say something that could be used against you right now, just so you know. And if you're trying to get a better bail from me, you shouldn't potentially incriminate yourself. That's a bad equation. But anyway, I'll let you say what you want to say. I just want you to be careful about potentially admitting to some of this conduct, because you face some serious prison time in this case. So you can finish telling me what you wanted to say. If it has to do with bond, etc., you can literally say whatever you want as long as you understand you have the right to remain silent about what you've been accused of. Do you understand that?
Yeah, I do.
Okay, all right. So go ahead.
And I want to know, is it possible where I could at least get ankle monitor or something like that?
I'm sorry. So this court will absolutely not do that. What it appears is you've got extensive history in California that on these facts, there is a strong implication that you came to Arizona only to commit this type of crime. There are many, many, many of them. They allege that they have it on video. The state, it will have 1, 2, 3, or 5 chances in this case alone to get you convicted and send you to prison. You have a very extensive criminal history. This court believes you are a serious flight risk and a high risk of committing new crimes. That if you are released, this list of facts plus your list of felonies equals a high risk of committing new crimes. So all of that, sir, means the court will not release you on anything less than very large amount of security. So you'll have to post that bail or talk to your lawyer next week about a motion to modify your release conditions. This court believes that you will run and you will commit felonies while you're running. So I'm not doing an ankle monitor in your case, sir. There's just no possibility. You'll step to your left, you get your paperwork.
Done talking to me?
I am done. Did you want to say one more thing?
Yeah, I was just gonna say I didn't come out here to commit no.
No, I understand. Of course, that would be your position. I understand that, and I'm not saying it's been established that you did that.
Right.
What I'm saying is there's a very strong implication, and this court is not going to take a bet on you, sir. You have more than 10 prior felony convictions. You are accused in, I just counted them, I forget, in at least 5 instances in which the presumptive you will face, if you are convicted in one of those, is 10 years in prison. And it's mandatory prison because of your priors. So the court believes that you'd have a strong motive to flee. The police allege that you are on video for these, and so that the likelihood of conviction goes up, and the likelihood that somebody might flee to avoid a conviction when they know that the state has a lot of evidence. So, Mr. Goodman, all of that adds up to this court believes you are very, very much a flight risk. If not now, after you meet with your lawyer and the state gives you a plea offer of 10 to 15 years. So if you'll step to your left, you can take your paperwork and talk to your lawyer. Your lawyer can advise you on the case going forward. Thank you. Mr. Tavern? Then Corral Morales Barba, will you please go to the chair? Hello, sir. Can I have your full name and your date of birth, please?
Clinton Tabron, 5/16/63.
Okay, thanks. Mr. Tabron, you're here on a new case. You were arrested for armed robbery by the threatened use of a deadly weapon.
For what kind of case?
Armed robbery by the threatened use of a deadly weapon. It is a Class 2 felony, and there is probable cause for it. I am appointing a lawyer for you. Is that the DO shouting back there?
Yes.
Oh, okay.
Yeah.
Right. You got a status conference June 11 at 8:30 in the morning and a preliminary hearing June 13 at 8:30 in the morning. And in this case, the court has considered your criminal history, what you are accused of. This court recognizes you're not accused of having an actual weapon, just threatening that you had one, which, in fact, does meet the elements of the crime. And so on these facts, with your history, which does you no favors at approximately 15 prior felony convictions, I will set what is a low bond for this type of charge, and that is $25,000 secured. You have to post it to be released. If you do, you are not to go to any part of the Family Dollar store on North 24th Street, no contact with any of its employees, no weapons or drugs without a valid prescription. Everything you need to know is on your paperwork. If you step to your left, you get a copy of it.
I don't carry guns, Your Honor. That's
all right, well, Mr. Tabron, if it had been a real gun, your bond would be more like $100,000. So this is a bond set because there's absolutely probable cause for this crime. You absolutely face an approximate 15-year presumptive prison term in this case. Number 3, these people did not know whether you had a gun, and they were every bit as frightened.
You're lying.
And
that's not true.
The court believes you're not going to voluntarily come to court for this, that you are likely to flee. You have an enormous criminal history. So, Mr. Tabron, you may disagree that the legislature criminalized claiming to have a gun, but they did. And those are the consequences that you face. This court finds it is a serious offense. And the much lower bond I'm setting is still very significant for the reasons that I just said. If it looked like it was a real gun, with your 15 priors, it'd be 100, maybe even 150,000. So this is the lower bond you're getting for the police alleging that you didn't actually have a gun. You just claimed to have a gun in order to successfully shoplift.
The officer
Talk
had
to your
the video
lawyer about this case, but Mr. Tabron, at this point in time, this court is not going any less than that.
So I can't be released?
Not unless you post that first. If you step to your left, you get a copy of your paperwork. Ms. Morales? Then Amber Wilson, will you go to the chair? Hello, ma'am. Can I have your full name and your date of birth, please?
Coral Morales, June 11th, 1984.
All right, thanks. You're in a new case and a warrant in an older case that has now been charged against you. So I'm going to start with the new case. You are accused from your arrest yesterday of 9 allegations of organized retail theft of merchandise. All of those are class 4 felonies. The alleged offense dates range from May 15th of this year to June 1st. There are 1, 2, 3, 4, 5, 6, 7, 8, 9 separate instances alleged. I did find probable cause for all of those, and I am appointing a lawyer for you. Your next court date is a status conference, June 11th at 8:30 in the morning in the downtown Superior Court, with a preliminary hearing June 13th at 8:30 in the morning in the same court. You have only one prior felony conviction, 2015, receiving stolen property. So on these facts, and with the amount of prison time you likely face, the court sets bail in the amount of $10,000. It is secured. If you post it, comply with all of your conditions. Do not go to any of those stores. No contact with those employees. You're also here on an arrest warrant in a case in which you've been charged by criminal complaint with possessing narcotic drugs, a class 4 felony, drug paraphernalia, a class 6 felony, DUI, alleged 4 different ways, each of which is a class 1 misdemeanor. And that warrant issued because I think they didn't have a working address for you. The alleged offense date, though, is back on September 25 of 2024, coming out of the Avondale Police Department. You get a copy of the police reports and the charges from your lawyer. You get to end up with the same lawyer for both cases. Same next court date for both cases. It's a status conference, June 11 at 8:30, preliminary hearing June 13 at 8:30. In this older drug case, because you would otherwise have qualified for release if you didn't come in on the merchandise theft case, I'm just setting a $50 placeholder bond. It's to make you eligible for credit in the drug and DUI case if you don't post bond in the other case. Everything is on your paperwork. That makes your total bond $10,050.
So I can bond out?
Okay. You can. Okay. And just know, if you miss a court date, you're getting a warrant, you're getting a bond. If you come in on any new felony allegation while the case is pending, you will be held without bond at this hearing. Okay. Don't miss your court date. You face a very real possibility of prison. You may not think so because this is shoplifting. As charged, speak to your lawyer about this. You face a very real possibility of prison. So you will only make your life worse if you don't show up for court or if you commit new crimes while the case is pending. You're already in a very bad situation based on what's been alleged. Don't make it worse.
Okay.
You step to your left, you get your paperwork. Thank you. Ms. Wilson? And then Andy Chavarria, will you please go to the chair? Hello, ma'am. Can I have your full name and your date of birth, please?
Amber Wilson, 05/12/1988.
Thank you. You're here on 5 bench warrants that issued out of the same hearing. It was a sentencing hearing in one case and a disposition hearing in 4 of them. The sentencing hearing was number 9 on the calendar, where you've been charged with dangerous drug possession, class 4 felony. In each of the other cases, you are on felony probation, and it was your disposition hearing. The date of that hearing, I think I already said it, but it was May 14th of this year. You have a lawyer in all of these cases. You're going to have a status conference in front of your sentencing judge. That's in the pending case. That's number 19 on the calendar. The same day, it's going to be set for disposition hearing in the other cases. It'll be up to the judge whether you go to sentencing and disposition. It's going to be June 11th, which is 6 days from now. They may, if the pre-sentence report is done and everybody agrees, they may go to sentencing, or they may set it out and give you a sentencing date. That's up to your judge. But what I'm giving you is a status conference and possible disposition hearing. June 11th, 8:30. I'm affirming the judge's bond in all 5 cases. It is $2,500 secured in each case for $12,500 total. If you bond out, apply with all of your conditions. Do not miss your court hearing. Call your PO within 72 hours.
I can't do the ankle monitor?
No, no chance, ma'am. What part of 5 felonies?
Well, I know.
What part of that makes you think that I would let you out on an ankle monitor?
Because I contacted my public defender that day that I wasn't going to make it.
You didn't self-surrender? No, you didn't.
I wasn't supposed to.
No, not a chance, ma'am. No.
Okay.
Please step to your left. Mr. Chavarria, and then Raymond Norman, will you go to the chair? Hi, sir. Can I have your full name and your date of birth?
Andy Chavarria, 26, 1971.
Okay, thanks. You're here on a new case. You got arrested for possessing narcotic drugs, a Class 4 felony, and drug paraphernalia possession, a Class 6 felony. I am appointing a lawyer for you. Pretrial gave me a note saying you didn't want a lawyer, but I have to give you one. If you still want to waive counsel, you can do that. You may have done it before, but it's a formal proceeding.
Okay.
The public defender will literally help you try to go self-represented if that's what you want. But I'm going to appoint a lawyer for you because I need to do that to make sure that the appellate record is protected and your rights. You can waive counsel at a future hearing if you want to, and the court lets you.
Okay.
So, don't be mad. I am appointing you a lawyer. Your next court date is the status conference, June 11th at 8:30. Preliminary hearing, June 13th at 8:30. Based on your criminal history and the evidence against you, this court believes bond is appropriate. I'm setting it in the amount of $2,500 secured as recommended by the state. If you post it, comply with all of your conditions. Do not miss your court dates. I don't think you're on parole. I didn't have time to look.
No.
Okay. All right. Then you're good. All right. If you step to your left, you get a copy of your paperwork. Mr. Norman, Raymond Norman. Sal Romero, we go to the chair. Where's Raymond Norman? Or Sal Romero, if you're ready, you can come in. Yeah, Mr. Norman can sit and wake up. Mr. Romero, go ahead and come in. Yeah. All right, Mr. Romero, can I have your full name and your date of birth?
Saul Romero, 05/20/1985.
All right, thanks. You're here on a probation warrant. You're on probation for a Class 4 felony, and there was a petition to revoke your probation filed on April 7th that alleges that you violated terms 3 and 5 of your probation. You'll get a copy of it from your lawyer. I am appointing a lawyer for you. Your next court date in the downtown probation court is June 12th, which is 1 week from today at 8:30 in the morning. That'll be a revocation, arraignment, and possible disposition hearing. Your bond is $500. It is secured. If you post it, comply with all of your conditions. Call your PO as soon as you get out. The number's on your paperwork. If you step to your left, the officer has that paperwork for you. Good luck. All right, Mr. Norman. And then Mariska Kinsel, will you please go to the chair? Hello, sir. Can I have your full name and date of birth, please?
Raymond Stewart Norman, 9/21/76.
Thank you. You're on a probation warrant. You're on probation for a Class 4 felony. And hold on a second. There was a petition to revoke your probation filed January 13th. It alleges that you violated terms 3 and 5. You'll get a copy of it from your lawyer. I'm appointing a lawyer for you. Your next court date is June 12th, which is 1 week from today at 8:30 in the morning. That'll be a revocation, arraignment, and possible disposition hearing. The court address in downtown Phoenix is on your paperwork. I am affirming the probation judge's bond, which is $750 secured. If you post it, comply with all of your written conditions. Call your PO as soon as you get out. The number's on your paperwork. Good luck. You can grab that paperwork from him. All right, Ms. Kinsel. And then Jordan Mankel, or Mankel, will you please go to the chair? Hello, sir. Ma'am, can I have your full name and date of birth?
Marissa Kinsel, 7/16/1987.
Okay, thanks. You're here on a warrant in a pending case. I think these might be failures to appear. Yeah, okay. One's a failure to appear at a status conference. That's number 6 on the calendar. Number 5 on the calendar. Okay, so you have 2 pending cases. On April 16th of last year, 2024, you failed to appear at a status conference, and there were warrants issued for your arrest. You already have a lawyer in both cases. You're going to have a status conference in both cases in 6 days, which is June 11th, 8:30 in the morning. The court address is on your paperwork. Your bond in each of these, I'm affirming the bond set by the judge who issued the warrant a year ago, and it's $500 secured per case, or $1,000 total. If you bond out, comply with all of your conditions. Do not miss any court dates. You step to your left, you have your paperwork.
I'm not being released?
You are not.
Okay.
All right, Ms. Mankel, and then Joseph Strumpa, will you go to the chair? Hello, ma'am. Can I have your full name and your date of birth, please?
Jordan Nicole Mankel, June 14th, 1998.
All right, so you're on a warrant from the Yarnell Justice Court, where you've been charged with driving on a suspended license, which is a Class 1 misdemeanor. It appears they have now also added an allegation of failing to appear in a misdemeanor case, which is itself a Class 2 misdemeanor. And this warrant issued April 15th of this year. So your next court date is going to be an arraignment hearing in the Yarnell Justice Court, 8:30 in the morning on June 10th, which is 5 days from now, Tuesday. Yeah, Tuesday, June 10th. Your bond is $500 secured. If you post it, you have to be up in Yarnell at that court hearing in 5 days, or you lose your bond money. There'll be another warrant issued for your arrest. If you don't post it, the sheriff, I forget what county that is. Yeah, I can't remember. That sheriff will come and get you from Maricopa and take you to that county. Everything you need to know is on your paperwork. Oh, and if you don't post bond, there will be a lawyer for you at the next court hearing just to help you with the bail issue. You don't otherwise get a court-appointed lawyer in a driving on suspended license case.
Can I get an ankle monitor? Because I'm not from Yavapai County, and I don't have my phone, I don't have my money, and if I get stuck up there, I'm not going to be able to get back.
Not on this type of case. No, there's no ankle monitor available, and we wouldn't do that on an out-of-county case anyway. This is an out-of-county case.
I can't get...
So the sheriff up there is going to have to, they're going to take you up there. How you get back from there, the court is not able to help you with.
So when do I go up there?
As soon as they come and get you, and that can be a shifting, we hope it is within the next 5 days. Talk to the sheriffs though, sometimes inter-county transport can be slow. It shouldn't be that slow to Yavapai because it's not that far away, but it's when the Yavapai County Sheriffs bring a van to Maricopa to get the Yavapai defendants. So if you'll step to your left, they'll give you a copy of it. Mr. Strumpa? After that, Sky Lowball, will you please go to the chair? You ready, Matt? Okay, I'll take you after this guy. Okay. Are you Mr. Strumpa?
Yes, ma'am.
All right, sir, give me your full name and date of birth.
Joseph Michael Strumpa.
I can't hear you, sir.
Joseph Michael Strumpa, November 10, 1980.
Okay, thanks. You're here on a probation warrant. You are on probation for a Class 6 felony. There was a petition to revoke your probation filed on April 29th. It alleges that you violated terms 3 and 5. I am appointing a lawyer for you, and I'm going to give you a next court date in the probation court of June 12th, which is 1 week from today at 8:30 in the morning. That's a revocation arraignment and possible disposition hearing. I'm affirming the bond set for you by the probation judge, and that is $250 secured with written conditions. If you post it, be sure to call your PO as soon as you get out. The number is on your paperwork. If you don't post it, they'll take you over for court next week. You can speak to your lawyer then. Good luck, sir. If you step to your left, get your paperwork. All right, she didn't come back. You want to wave at her?
Yep.
Okay. Are you ready? Okay, yeah, let's go. All right, yeah, you guys can both come up to the podium, that's fine. 1 second. Okay. All right, sir, can I have your full name and your date of birth, please?
Full name is Bailey Michael James Evanek, and date of birth is 12/03/1996.
Okay, and then the appearance of the state, please?
It's Dawn Sauer on behalf of the state.
Okay, thank you. And the defense?
Good morning, Your Honor. Sandra Schutz from Coach's Law Offices, appearing on behalf of Bailey Michael James Evanek, who's standing to my left.
All right, thank you. Okay, sir, you are here on a new case. You've been arrested on allegations of aggravated assault, a Class 3 felony, endangerment, a Class 6 felony, racing or exhibition of speed as a Class 1 misdemeanor, and reckless driving, a Class 2 misdemeanor. Before I make a determination, I am inclined to find probable cause based on what the police submitted, but did the defense want to be heard on probable cause before I move to release condition?
Yes, so I was going to argue regarding the aggravated assault and the endangerment that there is not enough information in the probable cause statement to show that my client in any way committed an aggravated assault or endangered anyone. It was another vehicle traveling at over 100 miles an hour, according to the probable cause statement, who struck the alleged victim in this case. So based on that, I was going to ask that probable cause be not found and that my client be released.
Okay, let me hear the state's response, please.
May I have a moment, Your Honor?
Sure, and I'm going to ask if the DO could stand behind the defendant when counsel addresses the court. Thank you. That's a safety issue, counsel. We do that.
I appreciate that.
For everybody. All right.
Your Honor, there is information in the Form 4 that the defendant was racing with the other vehicle prior to this collision. And a witness estimated their speed, plural, meaning both of the vehicles, to be around 70 to 80 miles per hour.
Okay, I'm sorry, I don't want to cut you off. Are you still thinking?
I was just scrolling through to
Oh,
see
no
if there
problem.
was anything else. I don't see anything else that I would like to mention.
Okay.
And Your Honor, if I could just And Your Honor, if I could just jump in.
Go ahead, ma'am.
A lay witness estimating speed, I don't know how reliable that is. Also, all the other data was taken from the Camaro, which is not the vehicle that my client was driving. He was riding a motorcycle. Also, he only suffered some road rash and potentially a torn ligament. He felt that his shoulder felt uncomfortable after he then hit some road debris and slid off his motorcycle or was ejected. So I think if he was going at a greater speed, it's highly unlikely he would suffer only those pretty minor injuries, given that he was on a motorcycle. So for those reasons, I'm asking that no probable cause be found. Thank you.
All right, thank you. And so it's Mr., I think, is it Evanek?
Yes.
Okay, thanks. I've considered what's been alleged against you by the police, the arguments of counsel here in court today, and I have considered the statute. The statute for aggravated assault, it subsumes the statute for assault, which is 13-1203. And under 13-1203, aggravated assault does not have to be committed by intentional conduct. This court finds that on these facts, what's been alleged against you, and I believe we all agree that it is not alleged that you were driving a vehicle that struck the victim vehicle. That is not alleged. I do understand that. But that on these facts, your actions made you an accomplice to the activity that had as a foreseeable consequence the injury to another person, and that you did that either or both knowingly or recklessly, and that is all the criminal intent that is required for the aggravated assault statute. So this court believes that to a degree of probable cause, which is not beyond a reasonable doubt, it is a lower standard, but the police have established probable cause for both the aggravated assault and the endangerment, because that's a similar type of equation in terms of were you a participant in activity to a degree that would make you criminally liable for those foreseeable outcomes. This court believes probable cause has been shown that you were. So I do find probable cause for both the aggravated assault and the endangerment felony allegations. Counsel, that likely streamlines the release condition discussion, but I'm going to hear from the state first. Go ahead, ma'am.
I'm just trying to pull up my recommendation, I believe. Your Honor, the defendant was on felony release in CR 2024-130232 at the time that this offense occurred, and for that reason, he should be held non-bondable.
All right, and Counsel Schutz?
Thank you, Your Honor. Given the statute, I don't necessarily have a legal argument, but I would like to put it on the record that in that matter, the state was willing to dismiss all the felony counts and had offered Mr. Evanoff a misdemeanor plea. However, he had denied taking that. So I just want to put that on the record. However, technically, he was still on felony release because those charges had not been dismissed at the time of this alleged offense.
Okay, understood. And Counsel, I just realized you did an initial appearance only. Should I go ahead and appoint the public defender in the new case as a backup?
For the time being, yes.
Okay, all right.
Thank you.
So, Mr. Evanoff, as I'm sure your lawyer explained, there is a provision of the Arizona Constitution that is carried through the statutes and the rules that say that if I find probable cause for a new felony at this hearing, because you had a pending felony case, and that is an unfortunate series of events, you did have a pending felony case. And so I'm unable to give you bail today. I must set a bail hearing for you. The bail hearing, so let me give you your court dates. You're going to have a status conference June 11, 8:30 in the morning, with the preliminary hearing June 13 at 8:30. The court finds that you were on pretrial release in a separate felony case, and that is defined as admitted to bail. Admitted to bail does include own recognizance release. So you have to go to a bail hearing. It is an evidentiary hearing on the subject of whether the state has enough evidence to continue to have you held no bond. So you may or may not be found eligible for bond at the bail hearing. That's going to be June 12th, 1:30 in the afternoon. So you are ordered held no bond at least until that time in this new case. Okay. All right, and I think everything else is going to be on the paperwork. Anything else from the state?
No, Your Honor, thank you.
Okay, we're going to get that printed for you, counsel. If you want to keep, we do have to reprint it because I appointed the public defender. If you want to have a seat, if you want to keep using the room, it's fine. I've got quite a few more matters to go. Did you want to be excused?
I do.
Okay, all right.
Thank you.
Then you're excused, and we are moving on. Thank you. All right, Ms. Lobos, Sky Lobos. All right, and after her will be Joseph Arriaga Stevens. Hello, ma'am. Can I have your full name and your date of birth?
Sky Lobot, 10/31/1990.
Okay, thanks. You're here on 2 probation warrants. You're on probation in 2 felony cases, and there were petitions to revoke your probation filed on April 3rd. They allege that you violated terms 3, 4, and 5 of your felony probation. You'll get a copy of those from your lawyer. Pardon me. I am appointing a lawyer to represent you. The next court date is going to be the same for both. It's 1 week from today, which is June 12th at 8:30 in the morning in the downtown probation court. That's a revocation, arraignment, and possible disposition hearing. In number 38 on the calendar, you have a $500 secured appearance bond. In number 37 on the calendar, you have a $250 secured appearance bond. That is $750 total. If you bond out, comply with all of your release conditions, and call your PO as soon as you get out. The main number is on your paperwork. If you step to your left, he's got that. Mr. Arriaga Stevens. And then Malcolm McCann, will you please go to the chair? Where's Mr. Arriaga? Here he comes. And then Malcolm McCann to the chair, please. Hello, sir. Can I have your full name and your date of birth?
Arriaga Stevens, 062901.
First name Joseph?
Yep.
Okay, thanks. You are back in court because 2 warrants hit the system for you out of Peoria City Court. In the first one, you've been charged with resisting arrest as a Class 1 misdemeanor. In the second one, you've been charged with shoplifting as a Class 1 misdemeanor. You're going to have the same next court date for both. It is June 10th, which is this coming Tuesday at 9 in the morning in the Peoria City Court. And I'm just setting $250 secured appearance bond in each case. I know you have a larger bail in the other case. And if you don't post it, which you won't, on the 10th, you'll have a lawyer there to help you with the bail issue only. If you're still in custody in 5 days, you will be transported to Peoria for these hearings, okay? All right, if you step to your left, you get that paid for. All right, Mr. McCann, and then Katrina Hansen, will you go to the chair?
How you doing?
Hi, sir. Yes, it's always very cold in here. Can I have your full name and date of birth, please?
08/1991.
Malcolm McCann?
Yes, ma'am.
All right, thanks. You're here on 4 matters. One is an arrest warrant for a newly charged case, and then what happened is that triggered the automatic term 1 holds in your 3 probation cases, because the new case is alleged to have happened while you were on probation. So let me tell you about that one first.
Okay.
You've now been charged in a criminal complaint with possessing narcotic drugs, a Class 4 felony, and drug paraphernalia, a Class 6 felony, back on December 9th of last year. And it looks like this comes out of the Glendale Police Department. But if that doesn't ring any bells, you're going to get police reports and the charges from your lawyer. You can go over with your lawyer what you're being accused of in the new case. So in the new case, your next court date is June 11th at 8:30. That's this Wednesday for a status conference with a preliminary hearing June 13th at 8:30. So when a new case comes in, it triggers automatic holds from probation. I think I didn't have time to verify it for sure, but are you serving out a probation sentence in one of your probation cases right now?
All my probation sentences I'm serving out. I've been in jail since March the 25th.
Right. What do you expect your release date is?
Today, technically.
Is it?
Yeah.
Oh, okay. I might do something different. Do you show that off? So I don't want to mess you over if you're wrong about that.
I'm like, good God, like what's going on?
Right. Well, it happens a lot, but most of the time when I see people in this, they've got another month or 2 left on the sentence. But you're telling me you're done. You're done for today. I'm going to try to run down which case that is. I didn't have time before court. Usually I try to run it down.
Okay.
Like which case are you being held on?
I'm being held on the.
It looks like it might be
shoplifting, facilitating.
I don't show any information. I just have to speak.
Okay. If I can find the confinement order, I'll be able to see it.
Well, can we do something about that?
Here it is. I found it.
Okay.
Just a second. Here's your actual confinement order, and it is in number. Oh, I missed it, but it's in CR 2024-106686. It is the shoplifting case. You were right. It says 120 days, 0 time served, not to be released until July 30th. So I was right.
On treatment.
So it says you're saying they found a treatment for you?
Yeah, that's.
Okay, wait.
This
right.
was.
Defendant shall be eligible for early release upon placement through reach out
Yeah.
or into a drug treatment or order previously approving. I think a new charge kicks you out of reach out, though. I think it does, unfortunately.
But
you caught a new case. So what I'm saying is,
I caught a new case before
you
the
caught a new case, right? This one from December. The county filed it, and so, and now I don't think you're going to be eligible for reach out. You know what though? I'm going to find out for you, and I'm going to ask. So go ahead and have a seat. I'm going to ask. I'm going to ask my clerk to call back to pretrial and ask them for me.
Okay.
All right.
All right. Thank you.
Sure. All right. Will you call pretrial and say reference number 35 on the calendar, which is reference that. Will the filing of the new case, will that make it ineligible for reach out? Let me look at his date. Yeah, because I see it on here that he was being processed for that. So if they say it won't, kick him out, then I'm going to release it. We'll kick him out. Okay. Reach out, right, for early release to reach out. That's my question. All right. I just want to know, I just want to get an accurate answer. Okay. All righty. So let's go to Katrina Hansen, please. And then Danielle Almanza, we go to the chair. Hi, ma'am, can I have your full name and your date of birth, please?
Katrina Hansen, 9676.
All right, thanks. You're here on an arrest warrant for an older case. You have now been charged, well, you got charged a while ago, I think, but now they found you, in a case in which you were accused of 2 counts of aggravated driving under the influence of alcohol or drugs. Those are class 4 felonies. I think it's the same incident, December 23rd of 2023, just alleged 2 different ways. They alleged you violated the 2 different parts of the statute. So those are both class 4 felonies. This comes out of the Mesa Police Department. You will get police reports from your lawyer. I am appointing a lawyer for you. Your court date is going to be a status conference June 19th at 8:30 in the morning in the downtown Superior Court. That is 2 weeks from now. Preliminary hearing June 23rd at 8:30. This is not a newly charged case. So what I'm going to do is release you to pretrial services with drug and alcohol testing. The court's main concern is that you're not driving without a license and killing other people. So no drugs, no alcohol. If you fail to do that, you fail to show up, there's going to be a warrant issued for your arrest, okay? Everything's on your paperwork. You're just going to get released with an envelope. The envelope tells you where to call when you get out. They're going to set up the testing. If you blow that off, I promise ultimately your defense attorney will be very unhappy with you. You step to your left, you get a copy of your paperwork. All right, Ms. Almanza, Danielle Almanza. And then Preston DeShazor, will you please go to the chair? Hi, ma'am, can I have your full name and date of birth?
Danielle Almanza, date of birth is January 27th, 1989.
Okay, thanks. You're here on a warrant in a pending case. This is one where there was an attempt made to send you a summons. They didn't have a current address, so it bounced and turned into a warrant. You have not missed any court dates, though. So, in this case, you have been charged with 21 counts of making a false statement to obtain benefits. Those are class 6 felonies. 1 count of theft by misrepresentation as a class 3 felony. 1 count of fraudulent schemes against the government. That's a class 5 felony. The alleged offense dates for all of these are back in August of 2020. I am appointing a lawyer for you. Your next court date is going to be a preliminary hearing, June 9th, which is 4 days from now. That is Monday. Today is Thursday. So Monday morning, 8:30, you've got a preliminary hearing in the downtown Superior Court. I'm going to release you on your own recognizance. These cases are either unemployment or welfare fraud almost exclusively. And so in these cases, generally, the people aren't flight risks. You don't appear to be a flight risk. And this case is fully 5 years old. So use your brain, be smart, go to court. Do not dodge this case, go to court. The court you're going to is literally, it's a calendar, it's a docket made up of the same kind of cases. It's an attorney general docket for welfare and unemployment fraud cases. So go there, meet with your lawyer. You'll have a very experienced lawyer in this type of case. They'll be able to give you advice about what they think you ought to do, what you're accused of, how strong they think the evidence is, all that business. But if you blow it off, you'll get a warrant, and then you definitely will get a bond. So everything's on your paperwork. You are released on your own recognizance, okay? You step to your left, you get that. Thank you. Mr. DeShazor? Why did that Santa Cruz keep reverting down? Everybody, I moved him up like twice. Have you noticed that? That like the cases don't say where you put them anymore? God, that is so...
10 and 20.
20.
The ones that are medical, sorry.
Is that why? Okay, it's like, why does that keep moving down? Okay.
Your Honor, both of them are here in the...
Okay, thank you. I was like, okay, now you told me that, and I was like, why? Okay. No. All right, can I have your full name and date of birth, please?
Yes, ma'am. It's Preston Allen DeSager, 6/22/83.
Okay, thanks. You're here on an arrest warrant for an older case. You've now been formally charged in a criminal complaint with possessing narcotic drugs, a Class 4 felony, and drug paraphernalia, a Class 6 felony, back on October 30th of 2024. So last year, this comes out of the Avondale Police Department. You'll get a copy of the police reports and the charges from your lawyer. I am appointing a lawyer for you. Your court date is in 2 weeks. The status conference, June 19th at 8:30 in the morning, with a preliminary hearing June 23rd at 8:30. And I'm going to release you to pretrial services supervision. It's not a newly filed case. You do have priors, but this is drug possession. So I'm willing to let you prove whether you will or won't come to court. If you prove that you won't, you're definitely getting a bond next time. So just show up, okay? On this kind of case, the state is making some probation and treatment offers. So you won't know that unless you show up. Of course, you're entitled to go to trial, but we will absolutely hold you on a bond if you don't show up, okay?
I'll be there, Your Honor.
Steps to your left, you get that paperwork. Good luck.
Thank you.
All right, Mr. Santa Cruz, please. Jose Santa Cruz, and then Richard Leach. We go to the chair. Hello, sir. Can I have your full name and your date of birth?
Jose Santa Cruz, 8477.
All right, thanks. You're on a new case. You were arrested for criminal damage as a Class 6 felony and disorderly conduct as a Class 1 misdemeanor. There is probable cause for those. I am not appointing a lawyer for you because you don't financially qualify. You have the right to hire a lawyer at your own expense or to represent yourself.
Okay.
Your next court date is a status conference June 11th at 8:30 in the morning with a preliminary hearing June 13th, also 8:30 in the morning. And in this case, considering what's been alleged against you, your, I think, relative lack of criminal history, let me double check.
Yeah,
No, that's not true. You have 3 felony priors. They're old. Old does not mean vanished. Old does not mean never happened. I recognize that one of them is 14 years old. The other 2 are even older than that and from another state. So it's not nothing. And by the way, sentencing-wise, it is not, it doesn't mean it's not usable in some ways. So talk to a lawyer about that. Certainly, I recommend you consider hiring one. All right, the state's recommendation in your case, one second, I believe is appropriate on these facts. That these facts, I believe this strongly indicates some danger to the community, and that it is very serious conduct that is alleged, although I recognize, as I think the state does, that what you're currently booked on is not as serious as the offense allegations would tend to suggest. So I am setting bail in the amount of $5,000 secured. Secured means you can use a bail bondsman. If you bond out, you are to have absolutely no contact with the alleged victims, no weapons, no drugs without a valid prescription, no alcohol. Everything you need to know is on your paperwork. If you step to your left, I'll give you a copy. All right, thank you. Okay, and then Mr. Leach. After that, I need to work on a couple of them before. Actually, maybe I want to clear for. I want to clear for the Spanish cases, actually, if I can. All right, Mr. Leach, can I have your full name and date of birth?
Richard Allen Leach, date of birth is 8/1963.
Okay, thanks. Mr. Leach, you got picked up on a grand jury warrant that issued for you a fair while ago. It looks like back in 2023, you were indicted on charges of aggravated assault on an officer, a Class 5 felony, resisting arrest, a Class 6 felony, and disorderly conduct with a weapon as a Class 6 felony. The alleged offense date for all of those is May 26th of 2021. And as I said, this indictment was handed down in 2023. So I am appointing a lawyer for you. I'm giving you a next court date of June 12th, which is 1 week from today, 8:30 in the morning. That's an arraignment hearing. This is not a new case, and you don't have any felony priors.
No.
So in this case, I am going to give you a try on pretrial services release. You are not to have any contact with any alleged victims. I want to reprint his 2, please, officer. I just realized, hold on, there's the disorderly with a weapon. I want to make very clear, no weapons, no drugs, no alcohol, obey any order of protection, don't go to the scene of the crime. I was thinking of this as just the ag assault on the officer. One of them is disorderly with a weapon. So I'm releasing you.
May I say something?
Not yet. I'm releasing you to come to court, but you're under orders not to have any contact with these alleged victims. Don't go to where this happened. Come to court, meet with your lawyer. Do you understand that?
Yeah.
Okay, because I, you know, if you're going to complain about that, you can. I just wanted to make sure you understood it, so go ahead.
Yeah. During that process, my wife died a year later after that.
I'm sorry.
And
was she an alleged victim in the case?
Yes.
Oh, okay. Well, that simplifies that. No contact order.
I've been homeless ever since I got into a place this past August.
I saw that, and that will help you. That you've got some housing that'll help you get to court. And like I said, I did give you a lawyer. Just don't miss your court dates, okay? So, and it may be that now they can't go forward on the disorderly with a weapon charge. Talk to your lawyer. They may not be able to. It's not, you know, I don't know the underlying facts because you got indicted by a grand jury. So the grand jury found probable cause. I don't even know what they are. So just comply with your conditions. There's still the aggravated assault and the resisting arrest, even if the disorderly with a weapon ends up getting dismissed. So just don't miss court, okay? Yeah. Don't miss court. If you want to defend your case, have all of this taken into account, I just need you to show up, okay? Yes, you understand that? All right. Everything's going to...
I just want someone to actually hear me from the justice system about what happened that night.
Okay. Well, and you are going to get your day in court. I'm giving you a lawyer. This is just the start of the case. I think the only reason... I mean, this turned into a warrant because we couldn't find you. And understood, and I'm not holding it against you. I'm actually giving you the benefit of the doubt and letting you out. Okay, I'm not making you post a bond. There was a bond set out of grand jury, but it was fairly low. It was $1,000, but that was 2 full years ago that bond was set. The offense conduct was 4 years ago. So I think you're probably okay. It's safe for the community to release you to pretrial services. All that means is you have to call in and check. You have to check in with them. You keep that envelope. The envelope will tell you how to call after you get out. They'll make sure that they're in touch with you as far as your address, when your court dates are, just to help the court keep track of you, help you keep track of your court dates. You just show up for court. Your lawyer will help you with everything that you just talked about, defending your case, having your say, getting your side of the story told, okay? Just don't miss court. All right, everything's on your paperwork right there. All right. So do we have our interpreter?
I told her at 12:10.
Oh, okay. All right. Yeah. Because so let me see if because there's the one guy and there's one guy I need to 27. I need to work on this really quick. Okay, I may be able to do him, and then we'll just have the FOJ to deal with. So give me.
I'm waiting for a call back from pretrial.
Okay. Thanks. Oh yeah, that one too. Right. Okay.
He hasn't dealt with the reach out program in years. He said that he needs to, but he's not sure about
And he didn't volunteer to find out?
I'm sorry.
I said he didn't volunteer to find out, obviously. I wonder if we can get Bill Peckham. Well, you know what? Never mind. No. It's fine. I know what I'm going to do. Thank you, though. That was singularly unhelpful. All right, Mr. Beckham, you can go ahead and come in, and you can print that whenever you're ready. Corey Beckham. And then, officer, depending on how long this takes, can we clear? I want to do the Spanish matters, and then I'll just have 2 people left.
Yes.
Okay, thanks. Hi, sir, can I have your full name and date of birth?
How you doing? Corey Dion Beckham, 5/16/1982.
Okay, thanks. Mr. Beckham, as you know, you're here on a bench warrant in a case in which you've been charged with conspiracy and patient or client referral fraud. Those are class 3 felonies. You already have a lawyer. I'm going to give you a post-warrant status conference in front of the trial judge. That's going to be June 10th, which is this Tuesday, 5 days from now, 8:30 in the morning. And pretrial gave me a note saying what you told them about you thought that the court date was different. So I like to run down those kinds of claims because usually defendants are wrong. In your case, what I found was an error in the minute entries. There was a minute entry in March in your case that set your trial procedure conference for June 3rd. Then there was a minute entry on May 9th that affirmed your trial procedure conference tomorrow, June 6th. And that on that basis, and I did confer briefly with the trial judge, she was all right with me releasing you back on the same conditions, no additional bond. So you said, pretrial said you thought your court date was next week.
Well, no, I had trial set for the 10th. So.
Yeah, and that's all been bumped out, which is why right now you have to go to what's called a post-warrant status conference. They're going to reset all that. Because when this warrant went out, they vacated everything. Wait a minute, it looks like...
So I
wonder if they did leave it on the books, because sometimes people get tried in their own absence. So it looks like maybe... Right now, they haven't vacated, so...
Well, they moved the trial to the 16th of
I know,
month.
so they haven't vacated it, which means the state indicated that they were willing to go forward in your absence. So I'm just trying to make sure you don't have any other court dates left on her calendar besides the trial. You don't. So mine is good. The 10th at 8:30. Her division knows about it.
They told me the 12th that I had something.
Yeah. So you have. So here's the thing. You have multiple court dates set in this case. You do.
Yeah.
And so but I need to make sure I give you the correct next one. And then you definitely need to walk out of there with a clear understanding between you and your lawyer, what's from here, which ones are from here. But the ones that I see that still exist are going to be mine, June 10th, 8:30. That is the status conference because of the warrant. So go square up with the trial judge, make sure everybody's on the same page. If you don't go, oh, she's definitely going to send a bond.
Oh, no,
So
I haven't missed no dates.
You're right,
except for that
I show that you are on the books for a jury trial starting June 12th. And what that means, what I deduce that means, is that the state said they wanted to go forward with the trial, whether you were there or not, which they can do. And so, because a lot of times if a defendant FTAs at a trial management conference, they just vacate the whole trial because the state doesn't want to go forward. But if the state says, oh no, we're ready, we don't care if he's here or not, then they leave the trial on the books. Your trial is still on the books, you're right, it says June 12th, but I'm adding a court date, June 10th. So 2 days before, show up, square up with your lawyer and the court will set whatever date she wants, or everybody needs to be in the same room and get back on the same page, and that's going to be the 10th. Go ahead.
One more question. I don't know if you can answer me, but I haven't talked to my public defender since March 17th. That's why I didn't know about the court date.
That's why it'll be good to go on the 10th, so at least you can say...
well, I was trying to, in the process of thinking of hiring a different attorney, but you can't speak on that. All right.
I cannot, and you'll have to talk to the trial judge. Depends, when you're this close to trial, the court may or may not let you do that.
I know.
So you have to talk to the trial judge. But, so what I'm doing is, your bond continues to be $10,000 cash, but I put a big note in there for the jail saying, that bond remains in place, but you do not have to post any additional bail in order to be released today. Okay. And so your $10,000 that you already posted back in November, it stays on the books. Okay. You're going to get the ankle monitor again before you go. They got to put it back on you, and then you're going to get released. So don't miss your court dates, particularly the 10th at 8:30, and that's all. Everything else stays the same.
Thank you.
All right. Good luck, sir.
Have a good day.
All right. All right, I've got my court interpreter, so can we please just clear down to, did we end up with only one Spanish? We did. Okay, because that one guy, I don't know why the police said he was a Spanish speaker. Usually they're right. Okay, and then we will continue in a bit with Mr. McCann and Mr. Vasquez. All right, so I need Mr. Mordano, if you'll come in, please. Mm-hmm. Okay. And are we clear, officer? Okay, great. All right, sir. Can the interpreter hear me?
Yes, Your Honor.
Okay, and thank you so much for your patience. All right, sir. Please wait for the interpreter, then tell me your full name and your date of birth.
Señor, espere, por favor, que interprete la intérprete. Dígame su nombre y su fecha de nacimiento.
Ciro Soberanes Muedano, 16 de junio de 1972.
Ciro Soberanes Muedano, June 16, 1972.
All right, thank you. You are here because you have been charged in a criminal case and there was a warrant issued for your arrest.
Está bien, gracias. Usted está aquí porque se le han imputado cargos en un caso penal y se había expedido una orden de aprehensión.
The charges are 2 counts of sexual conduct with a minor, which are Class 2 felonies.
Los cargos son 2 cargos de conducta sexual con un menor de edad que son delitos de la clase 2.
And 1 count of sexual abuse as a Class 3 felony.
Y un capítulo de abuso sexual que es delito de la clase 3.
The offense dates in your case range from 2013 to 2016.
Las fechas de los ilícitos en su caso son entre 2013 y el 2016.
And these charges were issued against you in 2018.
Y se habían entablado estos cargos en su contra en el 2018.
I am appointing a lawyer to represent you in this case.
Le voy a nombrar un abogado para asesorarlo con este caso.
Your arraignment hearing will be June 12 at 8:30 in the morning.
La fecha de su audiencia vista en coautoría es el 12 de junio a las 8:30 de la mañana.
And the court is going to affirm the bond set in this case by the judge who issued the arrest warrant.
Y voy a afirmar la cantidad de la fianza que ordenó el juez cuando expidió el orden de aprehensión.
That bond is $500,000 cash only.
Es una fianza de $500,000 solamente en efectivo.
You have other conditions you are ordered to comply with.
Usted tendría otras condiciones con las cuales tendría que cumplir.
Those include a mandatory electronic ankle monitor because you are accused of sex crimes against children.
Esos incluyen, es obligatorio llevar un monitor en el pie electrónico porque se ve acusado de abuso sexual en contra de menores de edad.
An order of no contact with the alleged victim or victims.
Y se ordena no tener contacto usted con las supuestas víctimas o víctimas.
No contact with anyone under the age of 18.
No tener nada de contacto con nadie menor de 18 años.
Do you currently have any children who are under the age of 18?
¿Tiene usted actualmente hijos menores de 18 años?
Sí.
Yes.
How many and what are their ages, please?
¿Cuántos y qué edad tienen, por favor?
2 años y 5 años.
2 years old and 5 years old.
Do they reside in this country or in Mexico?
En México.
¿Viven en este país o en México? En México.
En México.
En México.
All right. The allegations against you were brought as what is called under the law a dangerous crime against children.
Las imputaciones en su contra se han hecho bajo una ley que se llama delitos peligrosos en contra de menores de edad.
And that means that the alleged victim or victims in this case were under the age of 15.
Y eso significa que la supuesta víctima o víctimas de este caso tenían menos de 15 años de edad.
This court is otherwise unaware of what you are accused of because that evidence was presented to a grand jury.
Aparte de esto, yo no estoy enterada de qué más lo acusan porque esas pruebas se presentaron en un jurado indagatorio.
But the court is very concerned that your children may be or have been the victim of a similar type of sexually motivated behavior towards children.
Pero tengo mucha preocupación de que sus hijos, que acaba de mencionar, hayan sido víctimas de la conducta parecida de conducta sexual en contra de niños.
And that is because considerable research indicates that persons who have a sexual interest in children tend to victimize their own children.
Y eso es porque muchos estudios han revelado que la gente que tiene un interés sexual en menores tienen ese interés en sus propios hijos.
So for that reason, the court is forbidding any contact with your children unless and until you get a different order from the trial judge.
Y por esa razón yo estoy prohibiendo a usted tener contacto con sus hijos a menos que y hasta que el juez del juicio ordene una orden diferente.
And you can speak to your lawyer about asking for permission to have contact with your children.
Y usted podrá hablar con su abogado sobre pedir tener contacto con sus hijos.
You have other orders you must comply with if you are out of custody, including not going to the scene of the alleged crimes.
Tiene otras condiciones con las cuales tendría que cumplir si saliera en libertad, que incluyen no volver al lugar de los hechos.
And you may not leave the state of Arizona without the advance written permission of the court.
Y no puede salir del estado de Arizona sin el permiso anteriormente escrito del juzgado.
And you are ordered to surrender all passports to the clerk of the court at your next court date to be held until the conclusion of the case.
Y se ordena que entregue cualquier pasaporte que tenga a la Secretaría del Tribunal en su próxima audiencia y se quedaría ahí hasta que termine su caso.
Your complete orders are in writing. If you'll step to your left, the officer will give you a copy. Thank you.
Todas esas órdenes vienen por escrito. Puede pasar al lado izquierdo y recibirá una copia.
Okay, thank you so much to the interpreter. Really appreciate your patience with us today. Okay, take care.
Bye-bye, you too.
Okay, so Mr. McCann. All right, so I've got McCann and Busquets. Alrighty. Okay, and then go ahead, Mr. McCann, you can go ahead and come back in, right here. All right, I'm going to go back on the record in Mr. McCann's case, which is numbers 28 through 35, well, 28, 33, 34, 35. Okay, Mr. McCann, the answer we got, which is slightly incomplete, is that the people here at the jail, they also think there's a real possibility that this will make you ineligible at this moment for release to reach out, the fact that this case is pending. So I'm going to err on the side of caution, which is I'm going to set $50 bonds in each case and give you a court date next week. That will give your probation officer and your lawyer time to assess the situation. If you can still be ordered in to reach out, the trial court can choose to do that. But at this point, I believe you will not be eligible for reach out. You'd have to be in jail until July 30th. You would catch a warrant in this case in late June. So releasing you is not the correct answer because it won't get you back to court in any event. I'm going to set these placeholder bonds. It's $50 per case. It's $200 total. You could theoretically post it and then hope that you go to reach out, but it seems like that could end very badly. You can end up with warrants and still not released and lose your bond money. And so I would certainly encourage you to wait until next week. Your court dates will be the 11th. That's the new case. That's Wednesday. Wednesday the 11th at 8:30. You'll see your lawyer then. That's for the new case with a preliminary hearing the 13th. Your probation court date is the 12th at 8:30. This is all in your paperwork. Chances are the court on the 11th will recognize that you have probation cases and they'll pull your probation cases into their court before you get there. But if they don't, when you get there on the 11th, your lawyer can work on getting everything together in the system, can work on figuring out, can you still go to reach out? What's the best option for you? So I'm going to set these bonds, but I'm going to give you court dates next week, okay?
Do you think, so the 120 days I was sentenced, correct?
Yeah.
I won't be sentenced to that anymore because of my violation of probation. It triggers a warrant, right? A warrant.
No, and unfortunately they both happen at the same time because every petition to revoke is like a different charge of violating probation. So right now you're serving that 120 days for that charge of violating probation. This is a new one.
Don't they cancel out the 120 days though?
Does it what?
It cancels out the 120 days because I'll be, I don't know, probably because.
Well, yeah, so. And you're eligible for some credit against that. Talk to your lawyer. It gets a little complicated, but I will say, in general, in cases like yours, which we do see a lot of, where you're resolving one probation violation, and here comes an old one because the county attorney finally decided to file it. If the new case is just a drug case, which yours is, it's not violent, there's no victim, chances are it's not going to derail the overall program for you. That would be your goal is, you talk to your lawyer, maybe you take a plea, maybe you want to fight it, that's up to you. But it should hopefully not delay your release by very much, and that if everybody's in agreement that you're still a good candidate for reach out, you're still a good candidate for probation, then that is still a likely outcome, even if you do take another conviction. But talk to your lawyer, especially the public defenders here in town, they are very well versed on how all of this works, what likely outcomes are, what you might be able to get, etc. So go talk to your lawyer next week. Hopefully this doesn't ultimately end up doing anything but delay your release to reach out, but that's not up to me. I'm just trying to make sure you don't miss the next court date and you don't catch a warrant when you're actually sitting in jail.
So if I post bond,
yeah.
What does that mean?
If you post bond, you're still stuck. If you post these 50, you're still stuck in on a confinement order until July 30th. My orders, just so the sheriff's office isn't confused, I don't think they would be, but I have an order in every one of your probation cases that says you still have to ride out any confinement order. I do not override that confinement order. I am not your sentencing judge. I'm not your probation.
The sentencing judge can override that.
Yes.
Okay.
The probation judge can do whatever they want because they have control over your case.
Right.
I have one teeny little hearing. I am not your probation judge.
Okay,
so that's why I'm saying, like, go next week. Many things could happen next week.
They could dismiss my sentence.
You could, like, take a plea and get sentenced on the same day. Many things could happen.
Okay,
So talk to your lawyer. Your lawyer will talk to the prosecutor and the PO. This is, unfortunately, like I said, this is a little itty-bitty initial hearing for you, just to give you some court dates and try to set this up as best we can for next week. All right, good luck, sir.
Thank you.
Or Mr. Vasquez? Hello, sir. Can I have your full name and your date of birth?
Edgar Roberto Real Vasquez.
Which date of birth?
50387.
Okay, thanks. You're in a warrant, Jefferson County, Colorado, where you have been charged with dangerous drug charges that also include, we get abbreviations. I don't have a copy of the warrant. I have what is called a teletype warrant hit, so it's a bunch of abbreviations. But it looks like it's controlled substance distribution in an amount over 112 grams, which I think is a quarter pound. Then, no, maybe that's it. It's controlled substance distribution over 112 grams. Oh, no, sorry. Consumption of non-prescription drugs and dangerous drugs. That's what was listed in the warrant from Jefferson County, Colorado. And it looks like this warrant issued on May 15th of this year. Again, this is out of Jefferson County in Golden, Colorado. So you have extradition rights here in Arizona. You can choose to exercise them and have an extradition hearing here in Arizona. You can also choose to give up those rights and agree to go back to Colorado without an extradition hearing. So let me just tell you what your rights are first. Did you get the card before court, the card to read?
Yes.
Your rights? Okay, good. So I just like to summarize it for people because that card is dense with information. So you have 4 basic rights in an extradition case here. One is the right to have the extradition hearing within 90 days after today's date. The second is to get a governor's warrant signed literally by the governors of both states and presented to the Arizona court before you can be taken back to Colorado without your consent. That's your right to a governor's warrant. You have the right to hire a lawyer at your own expense to represent you in the extradition case. But this is not a criminal case. That's happening in Colorado. This is a civil case. So we don't appoint a lawyer for you if you can't afford one. You do have the right to hire one or to represent yourself. So the last right is the right to bail if you don't waive extradition. Colorado issued this as a no bond warrant outside of Colorado, but Arizona has a constitutional bail right. And there's very limited circumstances where you can be held no bond. This is not one of them. And so if you do not agree to go back, then you're going to be on the 90-day track. You're going to have an extradition hearing within 90 days. They're going to start working on their governor's warrant. And I'm going to give you a bail of $25,000 secured. You could bond out. You have to come to all of our court dates, or we will keep your bail money, and we'll issue an Arizona warrant for your arrest right on top of the existing Colorado one. And I will set your first court date over in extradition court, but again, you're on a 90-day track, so you have 2 or 3 court dates before your actual extradition hearing. I'll just be setting the first one for June 16th, 1:30 in the afternoon. So that's 11 days from now. That would be your next opportunity to waive if you ever wanted to. You never have to waive. You have the right to have that extradition hearing. Now, if you want to bypass that whole procedure and agree to go back, that's called waiving extradition because you have to waive all of your rights. You waive the right to the extradition hearing within 90 days. You waive the right to the governor's warrant. You can always hire a lawyer, but your lawyer won't have a court case to work on because the court case will end today if you waive your rights. There's no reason to have any court hearings. You're not having an extradition hearing. You gave up your right. Finally, you'll give up your right to bail for 30 calendar days because if you waive extradition, you must be held no bond for 30 calendar days so that Colorado has a chance to come and get you. The clock starts the day after you waive. So if you waive today, it starts on the 6th of June. If you waive it, your next court date will start on the 17th of June. And you sit for 30 calendar days and you wait and see if they come and get you. You do not go to court. You don't do anything. You just wait. If they don't come and get you, you get released on the 31st day, but the warrant stays active in the national system, and you could literally be re-arrested on the identical warrant. It does happen. So I just always warn people about that because they'll say, this is the third time I've been arrested on that warrant. And I say, we tell you guys every time, you have to do something about it in Colorado because I cannot quash a Colorado warrant. Only a Colorado judge can. So if you get released and you ignore it and pretend like it went away, you're going to get rearrested on it. So, all right. So you got the 90-day plan to have an extradition hearing.
The fastest I go.
Okay, so you want to give up your right to an extradition hearing?
Yes.
Okay, let me read you. I have to read you. I use a script so I don't mess it up. I have to establish that you do understand the rights you have, and then I'm going to ask if you want to give them up. So, did you read the waiver paperwork we gave you? That was the card?
Yes.
Okay. Do you understand?
Yes.
You do not have to sign the waiver. Do you understand you don't have to do this?
Okay. I'm willing to.
I just need to know that you understand that we're not making you waive extradition.
Okay. No.
All right. So I'll just ask again. Do you understand you do not have to sign this waiver?
Yes, I do.
Okay. Do you understand that you have the right to have an extradition hearing here in Arizona if you want one? Do you understand that?
Yes.
And do you understand that you have the right to hire a lawyer at your own expense for these extradition proceedings?
Yes.
Do you understand that you have the right to insist that governor's warrant be signed by the governors of both states before you are taken back to Colorado? Do you understand that right?
Yes.
Okay. And do you understand that that you have the right to bail? If you want to have an extradition hearing, I'm going to give you bail, $25,000 secured. Do you understand that?
Yes.
Do you understand that if you waive today and give up your right to the extradition hearing, that I must hold you without bail for those 30 days? Do you understand that?
Yes, I do.
Okay, all right. Then understanding all of that, do you want to give up those rights and sign the waiver paperwork?
Yes.
And has anyone threatened you or promised you anything to get you to do this?
No.
All right. And have you had any drugs, alcohol, or medication in the last 24 hours?
No.
All right. Then I find that you knowingly, intelligently, and voluntarily are waiving your right to an extradition hearing on this warrant and agreeing to go back to Colorado. My orders will direct our sheriff's office to notify Colorado you are ready to return. Colorado will have 30 calendar days starting tomorrow to come and get you. I did forget to say, so if this changes your mind, let me know, that if you have any Arizona criminal charges or holds, that Colorado's clock is not going to start until you're done with your Arizona case.
Yes,
you're okay with
I
that?
do understand. Yeah.
Does that change your mind?
No.
Okay, all right.
Just one question. My lawyer, she's gonna be contacting.
Your Colorado lawyer?
No, my wife got me a lawyer that would, wherever I go, that he will follow me.
Oh.
There's no. I forgot what she said.
So do you understand that in this case, though, if you sign this waiver, there's no more court hearings? You just wait for 30 days to see if they come and get you?
Yes, once I get to Colorado, my lawyer is going to be there for me.
Oh, I see. Understood. Okay, understand. Okay, all right. Any other questions?
Okay.
All right, then I'm going to sign it, and my clerk is going to have you sign a couple of times. You're actually signing the waiver, but she's going to give you a copy of what you're signing, and your 30-day clock will start tomorrow, provided you don't have any Arizona charges. I don't see any, but I always have to say that.
Good. One more question. Could it be earlier than 30 days, or it has to be?
It definitely can be earlier. It's whenever Colorado arranges for it. And so...
hopefully they come for me soon.
Exactly. Right. And there's no way to predict. It depends on literally that county. So Jefferson County might come faster than Adams County or Jefferson County. You know what I'm saying? And but our sheriff's office is going to notify them today. I know how they work. The sheriff's office has a whole office that works on extradition. So as soon as they find out Mr. Vasquez waived, they're going to be reaching out to Jefferson County and saying, we got one of your guys, let's start planning. And sometimes they don't come. That's why I warn people, if it happens to you, they don't come and you get released. You've got to do something about the case in Colorado or this whole thing is going to happen again.
Okay.
All right. Good luck,
Thank
Serge.
you
If you
so
step
much.
over here, she'll tell you when to sign. Thank you. All right. So for house calls, I got Jasper Fine, Zachary Spires, and Holly Cervantes. Are they not physically present in court because they've been isolated by the sheriff's office as a potential risk of danger to themselves or others?
That is correct.
All right, thank you. I've received an affirmative answer from sheriff staff, so I will go see those three defendants in the house to conduct their initial appearances in person in the cell block immediately following this recording. I will advise Jasper Fine that he's here on two matters. One is a new case, one is a probation hold. In the new case, he got arrested for robbery, a class 4 felony. There is probable cause for it, and I am appointing a lawyer for him. His next court date will be the South Conference, June 11, 8:30 in the morning, with a preliminary hearing June 13 at 8:30. And the court is inclined to set bail in his case in the amount of $10,000 secured with written release conditions I will go over with him, which include no going to the scene of the alleged crime or any part of that Circle K, no contact with any of its employees. He's also here on a probation hold, and I'll let him know that there will be a petition filed to revoke his probation. I'm appointing a lawyer. His court date in probation court will be June 12th at 8:30 in the morning in the downtown probation court. And based on what's been alleged in the Term 1 case, I believe that in all reasonable probability he is going to be revoked to prison in his probation case. So I'm ordering that he be held without bond in his probation case. Zachary Spires, born February 9, 1995, is here on a new case. He got booked in for aggravated assault, a Class 5 felony. There is probable cause for that. I am appointing a lawyer for him. His status conference will be June 11 at 8:30 in the downtown Superior Court, the preliminary hearing June 13th at 8:30. Based on what's been alleged against him, I do believe bail is appropriate, and I'm going to set that in the amount of $2,000 secured. That's my inclination in any event. The state's recommendation is $2,500. So I'm inclined to do $2,000 secured. With written conditions I'll go over with him, which include no victim contact, no weapons, no alcohol. All right, Holly Cervantes. Oh, I need to edit hers because the state did provide some probable cause for her. So hang on a second. I had a lot of moving parts. Okay. What's that? Thank you. Yes, thank you so much. I think we technically don't, but frankly, it's happened to me within the last year that it didn't work, so I still like to do it. All right, let's see. What are we looking for here?
I need to take this one out now. All right.
Okay. All righty. So let me see now. Come on. Okay. All right. So Holly Becerra Cervantes, born 10/29/76, is here on a new case. She was booked in on allegations of possessing dangerous drugs and drug paraphernalia. It's a Class 4 and a Class 6 felony, respectively. There is probable cause for those. There's also probable cause for the obstruction Class 2 misdemeanor. I am appointing a lawyer for her. Her status conference is June 11th at 8:30, preliminary hearing June 13th at 8:30. I'm currently inclined to set bail in her case in the amount of $500 secured with written release conditions I will go over with her. If anything changes after I conduct these initial appearances in-house with these defendants, I will update my formal written order. It's not the court's intent to update the recording in this case, and with that, we are going to stand at recess until 2 p.m. this afternoon.